Welcome to Law Experts MBA India. Can anybody confirm is my voice audible? Anyone? Hello.
It's audible, sir.
Thank you.
Yes,
Thank
sir,
you.
it is audible.
Thank you. Thank you, sir. So today's lecture we are going to see about the Trademark Act. This act is once again important because there have been two questions have been asked from this particular law. So we'll see that two of those questions also, and we'll have a general overview of the whole act. Just give me a minute. I'm really sorry for the interruption. So once again, please guys confirm me whether the voice is audible.
Yes, sir, it is.
Yeah, thank you, Mr. Nitish.
Yes,
So,
it is audible, sir. Audible.
thank you. So today's lecture, we are going to see about the Trademark Act. So this law was passed in 1999, the first thing. So whenever we are reading any particular law, we have to first understand why this particular law was enacted. So we have to see the preamble to understand the Trademark Act. So the preamble of this trademark law, what it says. Basically, it is consolidating and amending various laws relating to Trademark Act. And anyone, actually there is some disturbance. Mr. Mansingh, can you mute yourself? Okay. So we have to understand the preamble of the trademark law. First thing we can easily understand is that the first thing is to amend and consolidate the law relating to Trademark Act. There have been like 2 or 3 laws in the past with respect to the Trademark Act. So this law is amending all the things and consolidating the various laws which have been passed in the previous history. And secondly, this law is giving like registration for trademark. If you want to register a trademark, you can do this by the means of this law, very basic thing. Secondly, it is giving better protection for the trademark. When you're registering something as a trademark, this law is going to give you more efficient protection for this particular trademark, which you're going to register under this law. Thirdly, this act is enacted to make sure that there is not like fraudulent or like deceptive marks, which is nothing but, say for example, you might be like registering a trademark known as Sony. So this Sony, you will be knowing like it is famous for all the electronic products, say headphones or TV and everything. And if somebody is using the same word Sony and they are manufacturing something else also, like it's not just electronic product, they can begin like a manufacturing of cloth also. They can sell advertising agency, anything. So with the name Sony, this will create an issue with the trademark, right? Trademark, we need to understand the definition of trademark. That is a different thing. As of now, you have an understanding that this Trademark Act is enacted to make sure that there is no fraudulent marks in the place. Thirdly, to prevent the passing off. Passing off is nothing but you are representing yourself as something else. So similar example, I am a Sony manufacturer and you are like wanted to like manufacture some electronic product. You are naming yourself in a way that it is like violating my business. Like say for example, you are making a name known as once again Sony. So it is passing off. Passing off is nothing but you are passing yourself as something else, which is nothing but passing off. So first we need to understand the meaning of trademark. Trademark is nothing but for a particular product or for a particular service, a mark is attached to it so that we can differentiate from the other products. So we can say that it is constituting as a product differentiator also. We'll see multiple examples to understand that. Yes. So under the Trademark Act 1999, these are the various things which can be registered as a trademark. Say, for example, a name. So we have the logo of Tata. This Tata is a particular person. We all know that. So you can create a particular word and that word can be trademarked. Once again, any numerals can be trademarked. So this liquor example, you can take it. And a list of numerals can be, you can like get a trademark for that also. Letters. So if you take this F with respect to this design, so F is a particular single letter, right? So even this can be trademark, and that is a trademark logo one. We have device mark. Device mark is nothing but same thing. So it is nothing but for a particular letter or for a particular logo, yeah, artistic expression being applied to that thing, it is known as device mark. And the slogans we all know. We can take an example of, like, if you take the manufacturer Nokia, there is a word attached to that word Nokia, which is connecting people. So similar to that, any slogan which is distinctive in nature, you can get the trademark for that particular word also. Another recent example I can give you is that if you remember the word Byju's, they will always use the word think and learn. So this particular slogan can be attributed to that particular company alone. But if you want to get a trademark for a particular slogan, you have to make sure that it is distinctive in nature. Even a signature can be trademarked. 3D marks are nothing but a 3D kind of letter. Combination of colors, even a combination of colors, we can acquire a trademark. We are going to see that in detail. Shape of goods, you can see this particular Coca-Cola bottle for which a shape mark have been obtained in addition to the Designs Act. For even for a sound, a particular kind of sound, you can acquire a trademark which is known as sound mark. So you can remember any particular logo, like when you listen to when you switch off your Nokia phone, a particular sound will ring. Or if you remember any Britannia ads, like a biscuit company known as Britannia, you would be pretty well aware about it. So if you remember that word, a jingle bell sound will be coming at the end of the any particular ad of Britannia, that particular sound will be coming up. So even a sound can be registered as a trademark. So that is known as sound mark. Okay, we'll come to the trademark aspect once again. This is a very famous case. It was a Supreme Court case. So a ratio has been given in this case. So the Supreme Court was saying that trademark is the property of the manufacturer, say of a particular goods or of a particular services. It is considered to be a property right. And the main purpose of trademark, as per the words of Supreme Court, it was saying that this trademark will establish a connection between the goods and the source, and it will also suggest quality. So say, for example, when you're going to purchase a particular TV, you will always think about the word Sony or Samsung and you'll go and purchase it. You will not search for like lots of goods. Say if the trademark is not given at all, and in an electronic store, in an electronic store, you'll be like faced with lots and lots of television set. If these trade names are not registered, everybody will be using it. There won't be you won't be able to attribute any quality with respect to any particular words. So if the word Sony is not trademark, what will happen? Everybody will keep on using that word. I'll be manufacturing a TV, I'll be keeping that word Sony. And everyone who is manufacturing the TV, they will be like using the same words, and this will cause confusion in the public. So that is the main reason we have to give the protection for trademark. Yes. So as I just told you, it will establish the connection between the goods and services and the source from which that particular goods came from. And it will also suggest the quality of that particular good. Thirdly, it will help the consumer against the fraud or deceit of the quality of the goods. When you perceive the word Sony or when you perceive the word Samsung, you will know that it will have some quality, right? And when you think of that quality, you will go and purchase with any of these any of these manufacturers. If these things were not in place, then you have to check, say if these things were not in place, if you're going to a particular electronic store and there is no such trade name, what will happen to you? You have to, before buying any goods, you have to search for it. You have to make sure that a device which you're going to buy is working properly or not. It will take a lot of time for you. So this Trademark Act reduces such search cost. Whenever you see a particular trademark or whenever you see a particular brand name, you'll be able to associate the quality with respect to it, and you can reduce the search cost. Thirdly, it promotes the goodwill of the business. So whenever you attribute a particular word, you can, that particular word will have some goodwill. Goodwill is nothing but the reputation of that business. So the trademark will give you the goodwill over the business. Yes. This is another Supreme Court case discussing about the definition of trademark. In this case, the Supreme Court was basically saying that the definition given for trademark is very wide, because there are two elements are given for the definition of trademark. So that word itself is very wide and it is said to include many things. So the things which I just listed you here. So we'll understand the definition of the trademark first. In order to get a trademark, if you want to register a trademark, there are two elements you have to satisfy. First thing is like, it should be capable of being represented graphically. So what it means is that you have to go to the Trademark Rules 2017, and in the rules, the definition of the graphical representation have been given. So the word representation and the graphical means that you have to make some kind of representation either in paper format or in digital format, and that can be seen. If it can be seen, then there is no issue with respect to that, and it should be distinct. That is the second point. Yes. The second point is that for a trademark to be registered, we should be able to distinguish it from the other goods and services. So once again, the same example, you cannot like go to the trademark registry and say that I want to like apply for the trademark word Sony, because it is already there and there is nothing distinct in that word. It is already being used for so many years. You won't be able to get the trademark for it. So basically, there are two things with respect to trademark, two elements. First thing is that it should be capable of being represented graphically. Secondly, it should have some distinctiveness, which is capable of being distinguished from other goods and services. So the word represented graphically simply means that it can be, you should be able to give the register as to how it looks in the paper form or in digital form. You have to show the registrar, this is how the trademark will look for me. If you show that, that is sufficient. Yes, this particular slide we have already gone through. Yes, there is another case law with respect to the definition or purpose of trademark. We'll understand that also. A trademark identifies the product, its origin and its quality. So these things I have already told you. And a trader can have more than one trademark with respect to his brand, which is nothing but, once again, you take the example of Sony itself. In the Sony, there are various words. So if you go for the television, they have a particular kind of television known as Bravia. So this word Bravia is like a trademark. It's a word registered under trademark only, once again. And if you go for their PlayStations, the word PlayStation itself is like a registered. It's a gaming console. Everybody would be aware of it. So a particular manufacturer can have different kinds of trademark. There is no issue with respect to that. So that thing was like given in this particular case. And as I just told you, even a descriptive trademark can be given effect to, which is nothing but, we have seen the example of Nokia. So the word connecting people is like a descriptive words only, like common words only. But even though it is a common word, it can have some distinctiveness. If it has some distinctiveness, it can be registered under the Trademark Act. So these are the some of the examples I've given you. We can go through this. Yes. Coming to the very important question, whether a sound can be registered as a trademark or not. I've already answered you that. So if you can show the register as to like how this sound will, like with respect to music, you can have music notes, or how it will like eventually come to the place, like how it will sound actually. If you can like satisfy the register as to how it will sound, and if it has some distinctiveness, then you can get the trademark for it. So we'll see an example for Yahoo actually. Just give me a minute. I'm sorry, yes. Yes. So another example is that with respect to Britannia, you would have heard the sound Britannia. I think I don't want to play it because everybody would be using headphones, I believe, and sudden burst of sound will cause you some noise. So this is two examples I've given you for the sound marks. So the basically even a sound can be registered as a trademark if you can like have some distinctiveness in it. Secondly, if it can be represented in a graphical way. Two elements, keep it in mind. It should be able to represent it in a graphical way. Secondly, it should have some distinctiveness. If it if your mark has it, then it can be trademarked. Second type we are going to see is smell marks. Smell marks is nothing but a particular kind of smell, a particular kind of odor can be registered as trademark. But in India, we don't have such kind of smell mark as of now. The issue with respect to the smell mark is that it doesn't have the graphical representation. You won't be able to provide any notes for graphical representation with respect to smell marks. So that is one of the issues. And in this case, Sigma's case, what happened was a particular guy was like applying for the smell marks with respect to a particular substance, but this was rejected by the European Union because it did not have any graphical representation. But in the EU decision itself, it was saying that if you can have some clear, precise, and self-contained notes as to how it will smell, then you can get the trademark for it. So based on this particular ratio, if you go to the United States of America once again, in a particular case, like this company Oswes. So this company Oswes was like producing some kind of yarn, and this yarn was having a particular smell of this plumeria blossoms. Plumeria blossom is nothing but a kind of a flower. So this particular flower was having this particular smell, and this was given the trademark by the United States of America. Yes, we'll go to the chapter 2 of the Trademark Act. So firstly, in the Trademark Act, you have the registrar. So this particular registrar will be appointed by the central government under section 3 of the Trademark Act. So this trademark, the registrar will sit in a place known as trademark registry, which is established under section 5. So this registry will facilitate the registration of trademark, very simple. And in the registry, you will have the registrar, and this registrar has to maintain a registry, like has to maintain a particular register known as register of trademarks. In that particular register, he has to enter all the trademarks in a proper way as per section 6. And whenever he is entering any new trademarks, he has to classify it in a proper way. The proper way is nothing but there is an international classification of goods and services. This is as per the Madrid Agreement. So you have to classify, there are like around 45 to 48 classes. So based on that classification only, you have to maintain the register. This is as per section 7 of the Trademark Act. And whenever you like enter any particular trademark, you have to publish it in the alphabetical index page so that everybody can easily like understand how what are the trademarks which have been like entered into the register. Yes, we'll see the absolute grounds for refusal. So when you apply for the trademark, what happens? What are the things we have to see? Yes. So when you apply for the trademark, there are few grounds on which the registrar cannot give you the trademark. So we have to understand on what are the grounds you cannot get the trademarks. This is similar to the Patent Act. If you remember the Patent Act, there is a list of things for which you cannot get the patent. Say for invention, I'm sorry, not for invention, but for discovery or for any mathematical formula. So those things you cannot get the patent. This is as per Section 4 of the Patent Act. Similar to that, if you go to the Trademark Act under Section 9, for certain things you cannot get the trademark. So if you give like a particular name and that name is not having any distinctive character, then you cannot get the trademark for the same. And if you say something with respect, you give a name and which is indicating the kind or quality or quantity alone, or like it is having some customary practices alone, the word particular word is having nothing distinct in it, then the registrar will refuse to take your name. And if your name is, if it is accepted, if it will cause some public like I'm sorry, yeah, if it will, if it is affected by the registrar and it will cause some confusion to the public, then the registrar will not obviously accept your application. And if your name will cause some like hurt to the like religious hurt to any of the class of Indian citizens, then also the trademark cannot be registered. And there are like there are few names or few emblems which are prohibited under this particular law, like the Emblems and Names Act 1950. So for these names or for these emblems, you won't be able to get the trademark. This is as per Section 9. This is very important. This can be asked in the UPSC law optional. So these are the absolute grounds. There are some relative grounds. The relative grounds are nothing but if you apply for the like trademark and if it falls within this grounds, the registrar will call you and say that it is falling within these grounds. You will be given an opportunity of being explaining the things. And if you explain it in the proper way, you can get the trademark for the same. So we'll see the relating grounds. If you submit any application which is having a relation with the earlier trademark which have been already registered in the trademark register, then you won't be able to get a new trademark for it because it is simply already registered. You won't get the trademark for it once again. So identity and similar is more or less same. And if and the second cumulative condition is that if it is accepted, it will confuse the public. The same thing. In these kinds, you will get an opportunity to explain yourself why you have applied for this particular name. If you are able to satisfy the registrar with respect to that name, you'll get the trademark for it. If you cannot satisfy the registrar, then he will reject your application. Very simple. So certain chemical names, the chemical name as it is, you won't be able to register or you won't be able to get the trademark. This is as per Section 13. And with respect to Section 14, the names or the persons who have recently dead, their names you won't be able to get the trademark for it. This is as per Section 14. But however, you can keep their name as a trademark. You can get the trademark if you obtain the consent of this particular person. So say for example, I want to start like a electronic manufacture goods for in the name of APJ Abdul Kalam. So I have to get the consent of their legal representative. Before I do that, I have to get the consent of it. If I get the consent and if their legal representative are agreeing to that, then I can apply for the like trademark and I can get it. If there is no consent, then you won't be able to get the trademark for the same. And the trademark can be registered for the whole part or for series of parts, which we already discussed. So a company known as Sony will have a trademark for its TV known as Bravia and for its gaming console PlayStation, similar to that. And section 16 deals with the aspect of associated trademark, which will come to the in the later part of this lecture. So when you're applying for the trademark, it has to be applied by the proprietor. Proprietor is nothing but you should be a owner of a particular thing and you should apply for it. And you should have the desire to register. Someone is speaking.
Sir, can you hear me? Hello, sir.
Mr. Mansingh, can you mute yourself?
Sir, can I write my question? How do you speak? Like my voice is not audible. Can I text my question? Or can I chat it?
There is some noise coming from Mr. Mansingh or Ms. Prayati, I'm not sure. Okay. So this particular person, the proprietor, has to apply for this trademark, and he should have the desire to register. So he has to make an application to the registrar under section 18. So when the application is being submitted to the registrar under section 18 clause 4, the registrar, if he is satisfied that all the conditions of the trademark are satisfied, then he can accept it, or he can reject it if it is falling within the absolute grounds or within the relative grounds, which we have just seen. If he is accepting your trademark, then he has to advertise it. This is as per section 20. And whenever such advertisement is given, anyone who has any opposition over it has to go to the registrar and give their opposition. If they don't do it, okay, someone is causing, okay, no issues. So if there is no opposition from the end, then you can then the registrar will accept that application. So that is one thing. If it is opposed, then it will be like disputed by both the parties, and the registrar will decide on the favor of either of the parties. That is another thing. Yes. So if there is no opposition, the trademark will be registered, and this particular registrar will give you a certificate of register, and it will be entered into that particular register which he is supposed to maintain. So this registration is valid for first 10 years, and after that he has to renewal. So he has to pay the renewal fee to renew it every 10 years. So another, yeah, if he is failing to renew his trademark, and then another trademark can be allowed on the same name. So you have to make sure that you can renew it perpetually, like continuously you can renew it. There is no issue for it. Yes, coming to the UPSC law option question, I think this was asked in the 2017. Can anybody read it for me? Anyone?
When does the infringement, is I'm audible?
Yes, Ms. Nitish, yes.
When does the infringement of trademark occurs? Discuss the essentials of infringement of trademark. Write down the acts not constituting infringement of registered trademark.
Yeah. So basically, this question is asking you three things: when when a trademark is said to be infringed. Secondly, what are the essentials of the infringement? Thirdly, what are the acts which will not constitute as infringement? So for these three things, you have to refer two sections of Trademark Act, section 29 and section 30 of the Trademark Act. So we'll see the sections one by one. Under section 27, there is a particular right being vested on the registered trademark. So if you are registering your trademark with the register, you will have a particular vested right. That right is that whenever someone is using your trademark, you can prevent them by instituting a suit. By instituting a suit in the civil court, you can ask that particular person to stop doing that, and you can get the compensation for it. This is as per section 27. So what happens in case of unregistered trademark? You are using some brand name, you are having some brand name, but you have not registered under the Trademark Act as per the rules which we discussed. Then what happens to it? So you won't be able to institute a suit under section 27. So if your trademark is unregistered, you won't be able to do nothing about it except for the passing off, which will come to the later part of the lecture. As of now, this infringement proceedings can be begun by a person who have registered the trademark. So keep this simple point in your mind under section 27. So under section 28, it gives you the basic right. So whenever you have registered this trademark, you only have the exclusive right to use it. And under section 29, when a particular registered trademark is said to be infringed, we'll understand it by the section 29 clause 1. So when another person who is using another mark which is identical or similar to the registered trademark, then that is said to be infringement. Very simple. So when a person is using a mark in a course of trade which is identical or deceptively similar to the registered trademark, then it is said to be infringement under section 29 clause 1. And under section 29 clause 2, it is a kind of infringement. This is a second kind. If this identical or if it is being similar, then it will result in some confusion to the public, then that is also a infringement. So how this infringement might occur? So it is very simple. Another person will manufacture a TV and put a like name Sony in it. That is an infringement. So there is no need to go beyond that. So he will affix such registered trademark in his goods or package or in advertising also. So another example, I'll manufacturing a washing machine and I'll put the word Whirlpool in it. That's a registered trademark. I should not put that, but I still put that. That is an infringement. The Whirlpool company can sue against me. Yes. Can anyone read this para? So this para I have given you from this Amirdhara Pharmacy, which is Satyadev Gupta. This para is very important because this in this para you can understand that how this test of deceptively similar will be adjudicated by the Supreme Court. When two products are similar, how it should be like that particular issue should be resolved has been given in these words. Can anybody read it for me? Anyone?
Am I audible, sir?
Yeah, Miss Mispa, please read.
The Supreme Court in Amirdhara Pharmacy versus Satyadev Gupta says you must take the two words, you must judge them both by their look and by their sound. You must consider the goods to which they are to be applied. You must consider the nature and kind of customer who would be likely to buy those goods. In fact, you must consider all the surrounding circumstances, and you must further consider what is likely to happen if each of those trademarks is used in a normal way as a trademark for the goods of the respective owners of the mark.
Thank you. So basically, if you read this particular para, the Supreme Court was asking you to take the two words. So in the example I've given you with respect to the Sony, you have to take both the TVs and see, and you have to see like in which device this particular trademark is applied, or this particular name is applied to which device, and you have to consider the nature and kind of customer who is going to buy the goods. If someone is coming to a TV showroom and they are seeing the two kinds of devices having a same name but from a different manufacturer, then what will happen? So this particular person who is going to buy the particular television Sony will have the understanding that this Sony is like a manufactured by the Japanese company and not by anyone else. But in fact, if it was manufactured by a local company, it will create some confusion, right? It is like a nothing but a fraudulent act. It's kind of fraud one. So you have to see that particular thing, and you have to see the surrounding circumstances as to who are all the buyers, like what is their knowledge. If a person is going to the TV showroom and going to buy, what will be their knowledge? You have to assess it. And what will happen if you allow the word Sony and the another word Sony in the same place? What will happen? So it will cause some like confusion to the public, right? So it should not be allowed. So whenever a dispute comes in, you have to apply this particular test. So in this case, yeah, just give me a minute. Yes, I'm sorry about this. Yeah. Yes. So there is a particular case known as Vikram Stores with SN Perfumery Works. In this case, what happened was there was a particular person who was using the word Rangoli for manufacturing this agarbatti. Agarbattis are nothing but incense sticks. So this particular guy was doing it, Mr. X, we can assume. Another person came into being later, like Mr. Y, and started manufacturing another set of agarbattis with the same name Rangoli with the same kind of box also. So this person, Mr. X, gone to the court and said that, say, Mr. Y is also doing the same thing, and he is keeping the word Rangoli, which I have registered under the Trademark Act. So you please do something about it. And the court ordered the injunction against this particular guy, Mr. Y, and it asked him to stop it because both of them are same, and that is a registered trademark. You won't be able to use it. That is an infringement. That is the most important thing from this particular case law. So similar to that in Alagananda Cement versus Ultratech Cement, this guy was using the word ultra tough cement instead of the word Ultratech. He was using the word ultra tough cement, and this particular guy, the Ultratech Cement company, went to the court and was saying that this word ultra-tech will cause confusion to the public. So this should not be allowed. And the court said that, yes, you are right. The word ultra-tech and the word ultra-tough will definitely give some confusion to the public. Some people, like illiterate people, will also buy the cement for building their homes. So in that case, they won't be able to understand the difference between the ultra-tech or ultra-tough, and they will be simply misguided by the particular store seller also. So for this particular reason, this ultra tough cement was asked to stop using this particular name. Another example, Kellogg Company versus Praveen Bandhabai. In this case, this particular guy was using the word Kellogg's cornflakes. We all know the word Kellogg's cornflakes. It's very famous in the world. And another person was using the word Ames Arrowist cornflakes. So what do you think about this particular word? Whether this will cause any confusion to the public? The court said that these are distinctive words and have no relationship with whatsoever. The word Kellogg's have no relationship with the word Ames Arrowist. So therefore, it won't cause any confusion. This is not an infringement. So hope everybody is able to follow this and up to this point. So this is also a very important case, Cadila Healthcare versus Cadila Pharmaceutical case. The question whether this Falsigo and Falsitab were deceptively similar, and the court said that no, it is not similar. And while passing this judgment, once again it passed another set of like deceptive similarity test. So in this case also we have a particular test. This test is important, and once again this test is more important. In that case it was simply put. In this case it was properly given by the Supreme Court. So if a particular good is, whether a particular good is deceptively similar or not, we have to understand it by going through this particular guidelines of the Supreme Court. So we have to first see the nature of march, like what is the kind of goods in which it was applied. And we have to see the degree of resemblance, how the sign or how the words are being used in this particular product. Nature of goods, whether it is used for a TV or whether it is used for a refrigerator. These things you have to understand it. Similarity in the nature, character, or performance of goods, you have to see. Class of purchases, who is going to buy that particular good? We have seen the example of the cement case, right? Most of the people will be illiterate, will be buying the cement. So in that scenario, there should not be any confusion between the genuine manufacturer and the another person who is trying to use that particular name in a different way. And the mode of purchasing, how the goods are being purchased with respect to these two manufacturers, and the surrounding circumstances. We have already seen that. Effects of registration of trademark. So as I have already told you, if you have not registered your trademark, then you won't be able to file a civil suit for infringement and to get the damages for the proceedings. And this section 30 is very important because this has been asked in your question. Just give me a minute. Write down the acts not constituting infringement under the Trademark Act. For this particular part of the question, you have to write the section 20. I'm sorry, section 30. So if a particular trademark or if a particular trade name is used in a honest practices way with respect to that particular industrial or commercial matter, that won't be an infringement, first thing. And second thing, as per the law itself, if it is not having any unfair advantage or if it is not detrimental to the distinctive character or to the reputation of this trademark, then it is not an infringement. So we don't have any case laws or examples for this particular section, but there is only a one case law for this in this regard. Gonaka Institute of Education versus Anjani Kumar Gonaka. So there was a dispute between these two trusts actually. Both of these guys were like were running a school. One guy was running a school since 1995 and another guy started the school from 1999. But what happened was that this guy who has started the school in 1999 had a trust even before 1995 in the name of Gonaka. So whether the question before the court was that whether these two persons can use the word Gonaka, and the court referred to this particular section 30, and it said that both these persons were having an origin with respect to Gonaka, and they were not like doing it to infringe each other. So therefore, the court said that by applying the section 30, both these guys can use the word Gonaka in their school. There is no issue with respect there. There is no issue with respect to that. And both of these guys cannot claim infringement issue over each other. This is because if you see the section 13 of the Trademark Act, it has a principle known as honest concurrent uses, which is nothing but in a single time, in a single place, two users can use the same trademark, or like the trade name can be same, but it has to be somewhere different, and even in such a name they can use it. So we have seen this example of Gonaka, right? And when the two examples are being used in a concurrent way, what the registrar has to do is that he has to give a direction to the public in nature that, see, these two persons were a different person. You people don't confuse with respect to these two schools. Please make sure that this guy is different and that guy is different. So a registrar has to pass a direction in this regard. This is as per section 13 of the Trademark Act. So basically, even though these two things are deceptively similar, if it is like a honest mistake or if it is something like a honest usage, then it can be allowed by the registrar. Two trademarks can be there and a single name. Yes, this thing we have already seen, and the chapter 5 is not important for you. It deals with the aspect of assignment and transmission. Assignment as transmission is nothing but the proprietor of trademark can assign his trademark to another person, and he can give a license also. So he can give a license to another person to use his trademark, and he can share the profit with him. This is as per say chapter 5. And chapter 6 is like nothing but registered users. Registered users are nothing but the licensee himself. So the licensor is the person who is giving the license, and the licensee is a person, he is considered to be the registered user. So this registered user will be able to use this particular trademark along with the registered proprietor, and he can institute any infringement proceeding also. And but he cannot assign it to another person. He cannot give it to another person, but he can start infringement proceeding if someone tries to use the same trademark. So registered user is nothing but the licensee, and the licensor gives the trademark, like the license of the trademark to the another person. That person is known as registered user. Very simple. Yes. Can anybody read this question for me? Anyone?
The principle of passing off, sorry, the principle of passing off is when action has been extended to the use of false trade description. Explain the conditions for a successful passing off action and the difference available to the option party. 2010 UPSC.
Yes. So in this particular question, you have to write three things. How the concept of false trade description is relating to the word passing off, first thing. Secondly, what are the conditions or the elements of passing off? Thirdly, you have to write the differences which are available to the passing off. So we'll understand the concept of passing off. Yes. So passing off is nothing but a false representation, or like passing others' goods as yours. When you do that, it is said to be passing off. So a person is manufacturing a fake Sony headphones, and we have the real headphones also. So this person who is manufacturing this fake Sony headphones can be held liable under passing off also. So the difference between the infringement proceedings and the passing off is that the passing off is like a kind of common law remedy. So it is not given just under the statutory law of Trademark Act. This right of passing off, like the right to go for the passing off, to seek a remedy for passing off, this is like a common law remedy, and this is something related to the tort law actually, for which you can get the compensation in an unliquidated way. So this passing off, why when some person is doing the fake thing of a particular genuine product, why he is doing is that he want to acquire some profit by using your goodwill. So if you are the manufacturer Sony, and if somebody is like manufacturing the fake product, why they are doing is that they are stealing your goodwill, because the goodwill is already there, and they are simply producing this fake headphones so that they can steal your reputation or your goodwill. So as I just told you, passing off is kind of a tort law remedy, and this is based on the common law. It is not based on the statutory law. Even under the Trademark Act, even the unregistered trademark users can claim this passing off method, and using this passing off method, anyone can like go to the court, even though they have not registered on the Trademark Act. They can go to the court and say that this particular person is using my brand name, please do something about it. The court will apply the principle of passing off there. So this the principle of passing off is like based on a particular case known as Singer Manufacturing Company versus Luke. It's a very old case. Can anyone read this particular statement of this case law so that we can understand like the concept of passing off itself? Anyone? Okay, I'll read it. No man is entitled to represent his goods as a goods of another man. So no one is able to misrepresent yourself. So you should not misrepresent one good as another thing. And no man is permitted to use any mark, sign, or symbol or devices whereby he is making some like false representation to the purchaser. When he do that, he is said to do the act of passing off. So the word passing off has been there in the Trademark Act also, but the word, the definition of passing off is not given. But the word passing off has been mentioned under 3 sections of Trademark Act. I've listed out the sections for you. Under section 27 clause 2, the word passing off is mentioned, the first thing. So if you read this particular section, you can understand that, yes, nothing in this act shall deem to affect the rights of action against a person for passing off goods or services as goods of another person or of another services provided by another person or remedies thereof. Basically, this Trademark Act was saying that this law will not affect the right to go for the action of passing off. So the passing off is like a common law remedy, or like it's a kind of tort law remedy. You can go for it to the court directly, and you need not register your brand name as a trademark to apply this particular principle. So this is mentioned under section 27 clause 2. Under section 134, what is mentioned is that you can file a suit for passing off also. Earlier I told you that if you are a registered trademark, you can go for the infringement. But in case of passing off also, you can file a suit even for an unregistered trademark under section 134. And this suit shall be filed in the district court of that particular area where the proprietor carries on his business. Under section 135, what is a relief which can be claimed? So this area is somewhat complicated in the respect that in some of the jurisdictions, this act of passing off, like the principle of passing off, you can only stop the other person from using it because you have not registered your trademark. You cannot claim all the rights which is vested on a particular person of registered trademark. So in different jurisdiction, what happens is that you can only ask for the injunction. You cannot claim the damages for any of the any of the use of the by the other person. So, but in the India, with respect to passing off, you can do the injunction. You can stop the another person from using a trademark or the brand name. And secondly, you can claim the damages also. This is as per section 135. But in some jurisdictions, like in different countries of the world, you'll be only able to like get an injunction alone, not the damages. And with respect to the word false description, if you remember the question, the first part of the question was asking that the principle of passing off in an action has been extended to the use of false trade description. So the word false trade description have been defined in the section 21F of the Trademark Act. It basically says that in a trade description, you are putting some untrue words or you are putting some misleading words with respect to that particular goods, then that is a false trade description. So say for example, with respect to the Darjeeling tea, you put the word Darjeeling tea which is manufactured in Chennai. So that is a false trade description, right? And for which you can be penalized under section 103. The punishment would be from 6 months to 3 years of jail term, and fine would be from not the fine, yes, the fine from 50,000 to 2 lakhs, which the court will levy on you. Yes. So this concept of passing off will be applicable for the false state description also. So that thing you can write it by these sections. So we have to list out the conditions of the passing off, which is the part 2 of the question. What are the conditions of the passing off? These conditions have been listed out by the Judge Lord Oliver, and this Judge Oliver, what he did was that there is another famous judge, Lord Diplock, and he gave a guidelines of around 5 points. That 5 points have been summarized into 3 points right now. If you write these 3 points alone, these are the conditions of passing off. Just make sure that you remember the 3 points. First thing is that you have to establish that the actual owner who is coming to the court and seeking the passing off action has some goodwill or reputation over that product. Secondly, he has to say like the another person has misrepresented your goods only. And thirdly, you have to say that this the another person, by using my trade name or by using my brand name, has resulted in some damages for me. So these 3 points you have to highlight it before the court, and if you can highlight these points successfully, you will get the award or the compensation for the passing off, which would be the injunction as well as the compensation aspect. We'll see some case law for this matter. Bata India Limited versus Priory Roll. So in this case, this particular person, Priory Roll, was opening a manufacturing unit or a brand name known as Bata Foam. And we all know the word Bata is normally associated with the shoe-based company. And the court was saying this in this particular ratio, like the name Bata is neither a fancy name or a paternal name or any way connected with the defendants. Here the defendant is Mr. Priory Roll, and it is not the name of any flora or any fauna. It is a fancy name of a foreigner who has established himself in this shoe-based company. So whenever you say the word Bata, you will assume this particular brand is associated with the person who is a foreigner, and he has established the business in India, right? So this Bata you will also always associate it with this particular Bata, which is shoe-based company. So when you start a name known as Bata Foam, everybody will think that this foam-based Bata company is like another sub-segment of the Bata company itself. So this will cause confusion to the public, and the action of passing off was upheld in this case also. Another case, Honda Motors versus Charanjit Singh. So this we all know the Honda company, the Honda cars, and like Honda, we all know it's like an automobile company. And the defendant was starting a manufacture of this pressure cooker. He named this pressure cooker as Honda, and the court was saying that no, you won't be able to use the word Honda for these pressure cookers, because it will create some confusion to the public, because the word Honda is already having a lot of reputation. So if you put this word Honda in your pressure cooker, everybody will tend to think that this Japanese-based company, automobile company Honda, has started a separate unit for a pressure cooker also. So you should not mislead the public. So that name was given against the injunction. Another case, yeah, Sony Kabushi Kaisha versus Mahalakshmi Textile Mills. In this case, this particular person was like making some cloths, and he, in that particular cloth, he was like affixing the name Sony in it. But we all know the Japanese manufacturer Sony, who's manufacturing the all kinds of electronics. So the court said that no, you won't be able to use this particular word Sony, because this is like an infringement as well as the passing off. You should not do that. So in this particular case, there is a particular statement which is very important for you. It is like basically saying when the offense of tort of passing off is committed. So if a trader applies an established trademark in such a way that it will cause some confusion or deception to the minds of consumer, it is said to be the passing off. The essential gist of passing off is that another person applying the established trademark in such a way that it will result in confusion or deception for the public. If that is satisfied, then you can go for the passing off. Very simple. So in this particular question of law optional, we have understood that there are three parts. The third part being the what are the differences which can be put forth against the action of passing off. You can say that that particular brand name or that particular name or mark or logo is not distinctive. And secondly, you can say that since it is not descriptive, since it is not distinctive, you can say that it is very generic in nature and everybody can use it. Even the word apple, if you can remember, the word apple is like a registered trademark and it has been used for so many years. So you cannot go to the court and assert that this particular word apple used by the phone company Apple is like generic in nature because it is well established. Now you cannot like ask for its validity, right? And third difference is that they have used it carefully and in a honest way. So we have seen this Gonaka case wherein two schools were using the word surname Gonaka in their school name, and they had their genuine reasons for using it. So in that case also, it can be a good defense for you, and you don't have a goodwill. So actually, with respect to the word passing off, the first element being is that this particular guy has to have some goodwill or reputation in his business so that he can sue the another person for passing off. If his business itself doesn't have any goodwill, doesn't have any reputation over that particular product, then he cannot like succeed in his attempt of passing off. This is one of the defense. Yes. Another thing is like you have given the consent, the another person have given the consent or encouraged the use of this particular trademark. So right now he cannot come and complain, and you cannot able to demonstrate the damage or loss. So the third element we have seen that like you have to support your case with some kind of damages which is occurred due to the another person's usage. If you cannot like demonstrate the code as to like how you are like affected by this another guy's usage, then you won't succeed in your action of passing off. Yes. So with this, we'll complete the core important areas of the trademark. Right now, we'll have some discussion like on various thematic topics, like whether the domain names can fall within the trademark or not. In this particular case, Satyam Info versus CiFiNet Solutions, the court was saying that even a domain name is nothing but the word itself. Like in this particular, yes, the word Zoom. Just give me a minute. So this is a domain name. So the word domain, Zoom as meeting and all, it's like a domain name only. So even that particular domain name can be registered as trademark, because you have to understand the purpose of trademark. Why the trademark is given is to distinguish the goods and services. Nowadays in online, everybody is buying the goods and services in online, the e-commerce thing. So therefore, the main window of purchasing the goods or like purchasing the services is being done in online, and that is through with the help of domain only. A particular domain that doesn't get the registration for the trademark, what will happen is that everybody will start a name on the same website. So say for example, the Sony will have a single website only for its name. Nobody can use the word Sony in their domain, and they cannot create a website based on it, because even a domain name is a trademark. So this was asserted by the Supreme Court in this particular case, Satyam Info versus CiFiNet Solution. Yes. In this case of Yahoo versus Akosh Arora, the court was saying that domain name is like a valuable corporate asset similar to the trademark or trade names. So all the principles with respect to trademark will apply to the internet domain name also. Yes. We'll see the chapter 7, chapter 8, and chapter 9 are like not so important for you, but with respect to the collective marks and with respect to the certification trademark, I'll give you a gist of it in the end of the lecture. And chapter 10 is now omitted, which is nothing but the aspect of textiles, like how the textiles can get the trademark, which is now omitted, not applicable for you. Chapter 11 deals with the aspect of appellate board. When you are affected by the decision of the registrar, we have seen the aspect authority of registrar who should register your trademark, right? So when you are getting affected by the when he is not accepting your application, or when you are affected by the decisions of the registrar, you can go to the appeal to the IPAB, which is Intellectual Property Appellate Board. So, but this appellate board was recently abolished by the Tribunal Reforms Act. So the good thing is, like, we need not learn anything about the IPAB. That's a very good thing for you. The constitution, powers, and everything, you need not read about it, because that thing was abolished right now. But the question in the UPSC can be, why this particular thing is abolished? What will happen to those appeal? When you are affected by the decision of the registrar, then where you have to go for the appeal? And another type of question is that, why this IPAB was abolished, right? So we have to understand this. So first thing, this IPAB was like a appeal mechanism for all kinds of this IPR, like Patent Act or Copyright Act or like GI or Trademark Act. It is supposed to be the authority for appeal. Then you go to the High Court or Supreme Court based on what is given in the Act. So we need to understand why this IPAB is now abolished. First thing is that this, like, there is some technical members in it, there is some judicial members, there is some chairpersons in it. So basically, all these members were not appointed properly by the central government. So whenever any technical case come into the beam, the technical member was not there. So the bench was not there. Bench is nothing but one technical member, one judicial member should be there in the for to decide a particular case. The technical member is not there, then the case, you won't be able to decide that particular case. If you are not deciding the case in time, it will result in delay. That is another thing. And this IPAB was actually based in Chennai earlier. Before this particular tribunal was abolished, it was in Chennai only. If you go and see that IPAB, you will understand that the infrastructure or the funding aspect to the IPAB was not properly given by the central government. So this resulted in understaffing and many other issues. So therefore, the IPAB was not functioning well due to these reasons. And another interesting aspect is that it was there for 17 years. In that particular 17 years, for around 3 years, the chairperson was not there. So in that kind of scenario, we won't be able to like appreciate its existence, right? So it is better. It is like it has its own demise. So that is the main reasons like why this IPAB was abolished. These points are very important. It can be asked in your UPSC option. So what happens to the appeal from the register? Where you have to go to the appeal. So now you have to directly go to the appeal and file your case. If you have any decision, like any aggrieved decisions, which is given by the registrar. Very simple. Yes. Chapter 12D of the Trademark Act deals with the offences, penalties, and the various procedures. Some of the important sections I have listed out here. If you apply any trademark in a false way, then as per section 102 and 103, you'll get a jail punishment from 6 months to 3 years, and the fine will be levied on you 50,000 to 2 lakhs. Falsifying the trademark is nothing but the same example. You are manufacturing a TV and putting a word Sony in it, then you will be like punished under this particular section. Penalty for selling the goods or services to which the false trademark. So this is nothing but the showroom guys. You are putting the false trademark. You'll be liable under section 102 and 103, and you are giving it to the showroom guys. The showroom guys very well know that you are supplying a fake product only, but still they sell it along with the genuine goods. Then what happens there? The showroom person will get the punishment for selling this false trademark goods, and the punishment is same as the one we discussed earlier. And the penalty for improperly describing a place of business. So if you are registering a trademark, there is a burden on you to like give your address in a proper way. If you don't do it in a proper way, then you'll get the imprisonment and fine for that also. Falsification of entries in the register. So I was saying that in this register, in the office of registrar, there is a particular register where the trademarks are being entered, right? If you go and make sure you are like enter some irrelevant information, or you change some information, or you falsify the information in it, then section 109 will apply. The punishment is more or less same, 2 years of imprisonment plus fine. Here also 2 years imprisonment for plus fine. Yes, we'll see the aspect of well-known trademarks. This is also an important concept, but it is not asked in the UPSC law option so far. So what is a well-known trademark is nothing but the word well-known you have to associate with the word substantial segment of public. So if something is well-known, then it is known to most of the people in India or even in the world also. If you use that particular trademark, that particular trademark is said to be well-known trademark. So well-known trademark, say for example, you have the Apple. Apple is used by most of the people in the world, and everybody knows the word Apple is like it's like related to the iPhones or to the iPads or for the Mac. So this particular thing is well-known trademark, and this well-known trademark you can apply for the register, and the register can give you a tag known as well-known trademark, which is nothing but if it is known to the substantial segment of public, and if the registrar is like satisfied with that, then he will give a certificate that your trademark is well known. So basically, any trademark which respect to the well-known trademark, the registrar should not give the trademark for it if it is similar or if it is identical in nature. So how we can understand that a particular trademark is well known or not? We have to go to the section 11 clause 6. If you read this particular section, we have to see how much of people have the knowledge about this particular product or services, and what is their duration and extent of the use. For how many years they have been using, they have this particular product, and how many people are actually using it. And record of successful enforcement is nothing but in different jurisdiction, a case can be filed by this particular guy. Say in the United States itself, if another guy is using the word Apple for their manufacture of their phones, then this particular, the original Apple would have filed a suit against them, and they would have successfully enforced their right against the fraudulent guys, right? So when that kind of evidence is available, then the registrar has to give the well-known trademark to them. So with respect to this logo of Mercedes-Benz, it was said to be the well-known trademark in this particular case, the Daimler-Benz versus Haibo Hindustan. And the word Rolex is said to be the well-known trademark in this particular case, Rolex SA versus Alex Jewelry Limited. So another interesting aspect with respect to the well-known trademark is that it is not necessary that this particular trademark is being used in India, or it can be that it have been never used in India. So say for example, if the product of Apple is not used in India itself, that the iPhone device I'm saying, if it is not manufactured in India, or if it is not sold in India also, this particular manufacturer, by giving these facts, if he is able to satisfy these guidelines, he can get the certificate of well-known trademark. Basically, the usage or registration of trademark in India is not necessary for getting the well-known trademark status. So basically, it is like giving the trans-border reputation for the trademark. So everywhere, if it was like successfully enforced, you can understand that it is like a well-known trademark. And another thing is like there is an obligation on the register to make sure that he is not like taking any other trademark in the name of well-known trademark. This is as per section 11 clause 10. Yes, certification trademark. So what is certification trademark? We have to understand that. So if a particular guy in a particular course of trade is giving a certification, he is giving a certificate with respect to the origin or like a quality of the goods, and that particular guy can get the certifying authority can get the trademark for this particular word. So say for example, the Agmark is a trademark. This particular Agmark is given by a particular guy, and he will, whenever you buy any ghee and all ghee products, you will find it the word Agmark in it. So the word Agmark itself is like a trademark of the certifying authority, not of any of the manufacturers. So say if you are buying the Amul ghee also, it will have the word Agmark in it. If it has the word Agmark in it, it just means that it was certified by this certifying authority, and only the certifying authority will get this certification trademark, not the other person. Like say be it Amul or like Arvin or anyone else, or even you can take the example of ROKI, any example of ghee you can take it. These manufacturers won't get the certification trademark. There is a confusion in this regard. So only the certification trademark will be like acquired by the person who gives the certification, not the actual manufacturer of these goods. These manufacturers has to go to the certifying authority and get the certificate that their product is like complying the standards fixed by the certifying authority. So with respect to hallmark, we all know that it's a purity of jewelry, whether it is 22 karat or 24 karat. The word hallmark will be there in that particular jewelry to indicate the quality of that particular jewelry. So you just need to understand that the manufacturer did not get the certifying trademark. Rather, it is the organization which is giving the certificate getting the certification trademark. So these are various examples. So anyone who is complying with the conditions put forth by the certifying authority can use those words, AGMARK, or like ISI also. It's a famous word, ISI, and FSI. The word FSI will be there in every hotels or everywhere you dine. You will see the word FSI in it. So the word FSI is also a certifying trademark, and this FSI, you all know the Food and Safety Authority, right? So the Food Safety Authority will give you the certificate for it. Hope everybody is able to understand this particular law. So I was highlighting this aspect. The Indian law doesn't allow the proprietor of the certification trademark to use the mark in their own goods. So to put it in simple words, this particular guy, Akbar, he's giving the certificate to the other manufacturers alone, right? So he is having the certification trademark for the word Akbar. So he himself cannot start his manufacturing unit and start giving these agricultural product like ghee and all, ghee or butter or paneer. He cannot manufacture by himself. He is only a certifying authority. He has to remain as one. He cannot like start his manufacturing services. So please understand that particular difference. Collective trademark. It is a very simple concept. So like a particular association or a group of people coming together in a particular trade or services, and they apply for a trademark for a particular kind of goods or for a particular kinds of services, then it is known as collective trademark. So the word collective trademark is defined under section 2 clause 1G. It's a very simple definition. So we'll see some examples. So this Tamil Nadu handloom silk, you can see this logo, right? So it is a certificate given by the Tamil Nadu, this particular association. Like the goods, if a particular good is having this logo in it, then it is like nothing but like that particular silk saree or any silk material is manufactured by this particular guy only. So that is like the collective trademark. Another example, Chandoli Kala Chakwal, which is nothing but yes, in the Uttar Pradesh, there is a particular kind of association was registered for this purpose, and they want to promote the black rice in that particular area, and they have acquired the trademark for it. So these logos, when they acquire it, then it is known as collective mark or collective trademark. Very simple. Another important question nowadays is that whether you can get a hashtag, like whether you can get a trademark for a hashtag. Can anyone like give an answer for this? For a hashtag, can you get a trademark or not? Anyone? Okay, we'll see the answer itself. So nowadays, if you go to the Twitter or Facebook or anywhere in any digital platforms, you'll be able to understand that a particular company will be using a particular sentence or like a particular mix of words in the hashtag by themselves. So for this mix of words or for this particular sentence, they can acquire a trademark. Like they can acquire this particular set of words in the hashtag should be used by them only. So in Singapore, there is like a particular bank which was using the hashtag. They have got the trademark for a particular hashtag. So you have the Pepsi, the famous company Pepsi. So they have the like trademark for the word "say it with Pepsi." So nobody will be able to use this word "say it with Pepsi." The consumers can use it, but nobody else. Like another company, like say you can take the Coca-Cola itself. The Coca-Cola should not use the hashtag "say it with Pepsi." They use it, that is an infringement. So there is a Pizza Hut company. You all know the Pizza Hut. This is like in comparison to the Domino's. You have the Pizza Hut. Only the Pizza Hut can use the word "pizza me now" in the hashtag. They can only use it. Nobody can use it. That is also a trademark. But this aspect of a hashtag trademark is not popular in India as of now, but it is gaining popularity. Soon you'll have a trademark on the hashtag trademark also. Yes. So that is a very recent case as to like whether the suffix P, like we have the word phone pay and Bharat pay, right? So these are like different kinds of payment aggregators. So they had an issue over like who has to use the word pay in it, like phone pay or Bharat pay. But the court said that this word pay, the suffix pay, is like a common name only. Nobody can like claim any control over it. So with this, I'm completing the lecture on Trademark Act. Anyone, if you have any doubt over it, please feel free to ask me. Yes, Mr. Nitish, yes.
Sir, when you just speaking about the hashtag,
I'm really sorry, Mr. Nitish, your voice is not audible.
Yes, now it is.
No, Mr. Nitish, it's not audible.
Now
Can you chat? Can you put it in the chat box? I'll see it.
changing my network.
Anyone have any other doubt?
Sir, now it is.
Yeah, it is now audible, Mr. Nitish, yes.
Sir, hashtag cannot be covered under the slogans.
Yeah, it can be covered within the slogans, but the quote similar to how we are giving the recognition for the domain names, right? So we can say that the word domain name also, it's a kind of letters only, right, Mr. Nitish? We can say in that comparison, we can say that the domain name www.sony.co.in. It's like a set of words only. You are giving the trade, like you are giving the trademark for it. But here we are giving the recognition to the domain name. The word domain name is given, or like any kind of domain name, we are giving the trademark for it. Similar to that, we are here giving the concept of hashtag. So we are giving the recognition for the concept of hashtag, and although it is a sentence only, we are giving the like recognition for the hashtag, Mr. Nitish. Hope we are able to understand this.
Yes, sir. And
Yeah.
sir, one more thing.
Yeah.
So whenever there is a movement like hashtag me too and like they are using, and over this, they are after completing the tweets, they used to put the hashtag this so and so thing. So can this not be termed as a hashtags as a near a digital signature?
Can you like reframe your question, Mr. Nitish?
Yes. So this hashtags can sometimes be used as a digital signatures.
Digital signature you're asking. Okay. So actually any signature can be like you can get the trademark for the any signature also. So this hashtags, whether like it can be a digital signature, is not relevant for us as of now, Mr. Nitish, because the term hashtag itself can get the like the recognition of trademark, right? So similarly, the word any signature which is distinctive in nature can get the trademark. So I don't see the relevance of this question.
Okay.
Yeah.
Thank you, sir.
Thank you, Mr. Nitish. Yes. Anyone have any other doubt? So with respect to this trademark law, only two questions have been asked. The infringement part and the passing of part. Please read that part very carefully. For other aspects and all, you can go through this slide or our notes. That is sufficient. Anyone have any other doubts? Any general doubts?
Sir, Bharata
Yes,
here.
Ms. Bharata. Yes, Ms. Bharata.
So, Malati ma'am actually shares the previous year questions with respect to particular topics, sir.
Yes.
So, can we access that on our own from the portal? Is it
Yeah, actually, Ms. Varda, like in the website itself, like in the lawexpertsmv.com itself, like all the 6 subjects, like all the previous year question with respect to all the subjects have been already uploaded. I think like some like you're not able to like get the link for it. I'll share you the list of the 6 subjects, the link for all the 6 subjects, and all the topics for any given topic in the law optional. Previous year questions have been already made. It's there in our website right now. I'll share you the link in the WhatsApp, Ms. Varda. You can go through that.
Yes, sir. Thank you, sir.
Yeah.
So, one more question, sir.
Yeah.
This actually with respect to the environment class that we had, sir.
Yeah. Please tell me, sir. Yes.
The topic, the Wildlife Protection Act, that's not important, sir, as compared to environment.
No, it is also part of it actually. The Forest Conservation Act, the Wildlife Protection Act, everything is within the environmental law only. But we have not seen that, because if you see that particular lecture, I have gone through like around 4 or more than 5 or 6 laws. So Wild Protection Act is also important, but have not dealt with it in a detailed way because there has not been any questions from it. All the laws which have gone through in this environmental law lectures were like previously asked in the UPSC law optional, but this Wildlife Protection Act is also important for you. But I personally believe that you would be reading this in the environment with respect to the prelims or main subject itself. So when you're reading this GS portions with respect to environment, you'll be automatically reading this Wildlife Protection Act, the salient features, and that is sufficient for this purpose. Because the word environmental law covers each and every concept, Ms. Varda. It will be very difficult for us to cover these areas. So, and before the actual examination also, we have to make sure that if there is any current affairs relating to any particular environmental law, that thing is more important. So this aspect, there is a question on this access and benefit sharing with respect to the Biodiversity Act 2002. So this question was asked because on the 2018 or 2019, this Nagoya Protocol came into force. I think in 2018 only. So that was like a very important development because India was a signatory to this Nagoya Protocol also. And based on this Nagoya Protocol, our Indian government has enacted a guidelines also. So since that thing came in the news very frequently, I assume that there was a question in 2020. So similar to that, if you go through the past 2 years, like major developments, the any treaty to which the India has signed, or any treaty, any law which came into force very recently, those things only we asked in the environmental law. This is not just for environmental law. With respect to any question in the CLD portion, only the current affairs you have to give much importance. Even the static parts you have to give the importance, which we already discussed. But the current affairs part is like the current affairs part is more important. Anything which is occurring in the news, you have to read that in a proper way. Yeah, Ms. Varda, you have any other doubts?
No, sir. Thank you, sir. Thank you.
Sure. Thank you, Ms. Varda. Anyone have any other doubt? Anyone have any doubt? Mr. Ramandev is having some doubt. Okay.
Sir, no doubt.
Okay. Thank you, Mr. Ramandev. So I think we can end the lectures if no one has any other doubt. Okay, I'll end the lectures. Yeah, Mr. Nitish, yes.
Sir, the PDF for the schedule of constitution will be shared by
tomorrow it will be shared, Mr. Nitish.
Sir, if it's possible, then the lectures for the Sunday can be scheduled at the morning or the afternoons instead of.
Yeah, actually, we are planning to do that, Mr. Nitish, because some people are not convenient in the night and some people are not convenient in the morning. So actually, we are planning to have like a poll in this regard, like how many people is going to support this decision to have some lectures in the morning, even on the Saturday and Sunday. So we are planning to do that. Tonight we'll create a poll, and I think there are around 60 to 70 students are in it. And if everybody agrees to it, like if the majority agrees, we'll have some lectures in the morning also.
Sir, for the Sunday it is concerned. For Saturday we are having the college.
Okay, with respect to Sunday or in generally also we'll try that.
So, sir, there will be 2 batches or the.
A single batch only, Mr. Nitish.
Okay.
In the Sunday we'll try, yes. Because
Thank you, sir.
some people on Sunday will go to the coaching institute, right, Mr. Nitish? We have to consider that also.
Yeah, sir. If it is in the general interest, then it's not specific.
Definitely, definitely. Yeah, we'll create a poll, Mr. Nitish. Since you have a request, we'll ask the students and we'll come to a decision.
Thank you, sir.
Thank you, Mr. So I think we are good to end the lectures. Tomorrow you'll get the schedule for the constitutional law. Thank you so much.